Clement versus J&E Service, on the face of it, deals with a very narrow question of whether someone whose car gets towed without notice can state a cause of action under Section 1983 against the police for violation of her due process rights. Well, the short answer is yes, but not this time. I agree, this is a somewhat confusing answer, but it's an answer that's sure to be the same for all constitutional violations unless some other unlucky person has already had their rights violated in the same fashion and has already taken the matter up to the appellate court level. Well, in this case, the owner of the car had done what she's supposed to do with her non-operational vehicle. She registered it with the DMV under a planned non-operation certificate. She was living at a residential hotel, and she had permission of the hotel owner to park the car in that hotel's parking lot. She thought she did everything right. The police saw the car parked in the lot, ran a DMV check, and discovered that it had a planned non-operation certificate. It showed the address of the owner to be the hotel where the car was in fact parked. Now, the rules for such cars is that they can't be parked in parking lots that are open to the public. So the police took it upon himself to decide that the hotel parking lot was a parking lot open to the public, and without even attempting to notify the owner of the car, he hired a defendant tow company to tow the car away, which they did. Now, in the end, the Ninth Circuit agreed with the plaintiff that this was actually a violation of her constitutional right to due process, and that the government simply can't constitutionally tow the car without first giving the owner of the car notice that they're going to do it. But even though her constitutional rights were violated, she couldn't recover against either the police or the company that towed her car. Why? Well, because of government immunity in Section 1983 actions, and in the case of the tow company, because of what the court termed the defense of good faith. Now, the immunity for the police is really not all that surprising. We all know the rubric. Government officials performing discretionary functions have immunity from liability for civil damages if their conduct does not violate clearly established constitutional rights of which a reasonable person would have known. Well, because this determination of the constitutional question had never before been decided, it was not clearly established, and a reasonable police officer would not know of it at the time that this police officer towed the vehicle. Therefore, immunity applied to the police officer's conduct. Now, as the court indicated, there have been cases where the possibility of the existence of a defense of good faith available to private defendants in Section 1983 actions has been held open. In this case, the court held that such a defense actually does exist. So, now private defendants in 1983 actions can assert what seems to me to be almost more expansive than the government immunity defense, a defense of acting in good faith. Now, all this means that if there's no clear law finding that a particular method being used to violate your constitutional rights is in fact a violation of your constitutional rights, well, then you can sue under Section 1983 and clarify the law, but you won't be able to recover a dime. If you pursue the matter to the appellate courts, you might very well make new law, but you won't get to recover anything under Section 1983.